Hey guys, happy Super Bowl weekend. Gary here with another legal tip on cashier's checks, while they are actually dangerous for you as a real estate agent as well. I hope y'all have a good Super Bowl weekend. Cleveland Browns will be there next year. Mark my words, we have got an easy schedule next year, so I think that'll help us. So about cashier's checks, huge misconception in our market that cashier's checks are good funds. They are not good funds. They're quite frankly not much better than a personal check in a lot of cases. So what you need to understand with the cashier's check is that any human being can go to an office supply store, get check stock, go on their computer at home and create a fake check. And it would look just the same as your check or my check or anybody else's check from a bank. It's that simple to create a fake check. It's not hard at all. So there is the number one issue of the check can be just fake or fraudulent. The second issue is after closing, a consumer can go back to their bank and say, my check was stolen, please stop payment on it. And in most cases, the bank will stop payment. Well, the Supreme Court of South Carolina says that lawyers, you can't disperse on good funds. And if you do disperse on funds that are not good, you're responsible for them. So most attorneys have basically come up with rules that say, I'm willing to take this risk for this small threshold because I recognize that if we take a $10,000 check and it bounces and we've dispersed on it, we, the law firm, must make that money good out of our own funds. And so what you're seeing now is like Blair Cato, we have a $10,000 threshold of paying. That's as high as we will go is 10,000. But there's a lot of law firms, I've seen some as low as $500. And I certainly understand that prerogative, their reason for doing that, and appreciate the fact that they are doing that. I think ours could go down in the future because fraud is rampant. We know that. So let me give you a quick story about why we don't take cashier checks and why it's bad for you as the real estate agent. Up in the upstate, there was a transaction where the buyer sends in a $90,000 cashier's check. Not sure why any lawyer would ever take a $90,000 cashier's check. Like I said, it's like taking a $90,000 personal check. They deposit the check, do a closing for $60,000. So you might ask yourself, doesn't that seem odd that somebody would mail a $90,000 cashier's check for a $60,000 closing? Yes, it's extremely weird. And it's a huge red flag because we know what they're wanting you to do is to do the closing, wire the $30,000 overage back to you, and then watch their check bounce from here to Aruba. It's fraud. It's a common scheme. It happens all the time. I can't believe the law firm fell for it. But even outside of that, the law firm then dispersed the money to parties involved in the transaction, who then did what other parties do, what most parties do. They took their money from the transaction and spent it on personal expenses. So if I gave you a $15,000 commission check to your company and your company then dispersed it to you, what would you do with a $15,000 commission check? My bet is you would spend it on your mortgage payment, your car payment, and all the other expenses you have in your life. Well, in this situation, one of the parties spent the money. And then the law firm called them back and said, oh, by the way, the check we sent you is no good. It bounced. We need you to bring us our money back. Problem is they'd already spent that on expenses for themselves. They didn't have the money. And to make matters worse, the law firm even recorded the deed. So now the seller doesn't even own the property and the buyer's fraudulent. So you can't get a quick claim deed to fix it. It's going to have to be fixed all through a court hearing. An absolute mess, which would have been avoided with a reasonable rule on cashier's checks. We don't accept cashier's check over $10,000. So it's a prime example of why we're telling our clients, your client shouldn't be really using cashier's check. We're willing to do it up to 10,000, but that's it. The reality of it is, why can't your client just go ahead and wire while they're at the bank? If they got to go to the bank to get a cashier's check, they're already down there. They can get the wire done at the exact same amount of time, same amount of effort at the bank. And that way, when the funds come through, a wire is considered good funds and we can disperse, and we don't have to worry about a wire being called back later or being determined to be bad funds. So it's bad for you because I don't want to see you in a situation where your client delivers a cashier's check down to an attorney's office. They accept it, disperse your commission, and then the check's deemed to have been dishonored, and they have to call you back and say, we want your commission back. And you're like, but I've already made my car payment with it. I already made my house payment with it. I don't have the money. It's an absolute mess. Shouldn't do it. So be careful with it. That's one of the main reasons why I want to get this out about the cashier's check, because it can actually come back to hurt you as an agent as it did in the upstate. All right, y'all have a great weekend, and we'll be back with part 2 of the same story, a little bit more information on it next week. Y'all take care.